afternoon, class. My name is Richard Ruby. I did my PowerPoint presentation on Booth versus Maryland. This was Chapter 10. It dealt with the Eighth Amendment and what is actually considered to be cruel and unusual punishment. In 1983, Irvin Bronstein and his wife Rose were stabbed and murdered in the West Baltimore home. The murderers, John Booth and Willie Reed, entered the victim's home for the apparent purpose of stealing money to buy heroin. Booth, who only lived 3 houses away in the same neighborhood, knew that the elderly couple could identify him. The victims were then bound and gagged, and they were stabbed repeatedly in the chest with a kitchen knife. The bodies were discovered 2 days later by Bronstein's son. Before the sentencing phase began, the State Division of Parole and Probation, or the DPP, compiles a pre-sentence report that described Booth's background, education, employment history, and criminal record. Under a Maryland statute, the pre-sentence report in all felony cases also must include a victim impact statement, or a VIS, which describes the effect of the victim or the crime on the victim and his or her family. Although the VIS is compiled by the DPP, the information is supplied by the victim or the victim's family. The VIS may be read to the jury during the sentencing phase, or the family members may be called to testify as to the information that was presented. So Maryland Code back in 1986, it's most likely definitely changed since then, basically said that it must have all of these appendages. So it must identify the victim of the offense. It must itemize any economic loss suffered by the victim as a result of the offense. It must identify any physical injury suffered by the victim as a result of the offense, along with its seriousness. It must describe any change in the victim's personal welfare or family relationship as a result of the offense. It must identify any request for physiological services initiated by the victim or the victim's family as a direct result of the offense, and it must contain any other information related to the impact of the offense upon the victim or the victim's family that the trial court requires. So, the prevalence of the victim impact statement reveals several assumptions about the purposes of punishment. Punishing the defendant according to the degree of harm caused achieves two utilitarian goals. It permits the victim and society to express their outrage at the evil the defendant had caused. It incrementally deters the underlying criminal conduct, and in addition, it is widely believed that achieving the retributive goal of inflicting a fair or deserved punishment necessitates some consideration of post-crime victim suffering. So, the VIS in Booth's case, it come down with interviews from Bronstein's son, daughter, son-in-law, and granddaughter. Many of their comments emphasized the victim's outstanding personal qualities and noted how deeply the Bronsteins would be missed. The son, for example, said that he suffers from lack of sleep and depression, and he is fearful for the first time in his life. He said that in his opinion, his parents were butchered like animals. The daughter said she also suffers from lack of sleep, and that since the murders, she has become withdrawn and distrustful. The daughter concluded that she could not forgive the murderer and that such a person could never be rehabilitated. The granddaughter described how the deaths had ruined the wedding of another close family member that took place a few days after the bodies were discovered. Both the ceremony and the reception were sad affairs. Instead of leaving for her honeymoon, the bride attended the victim's funeral. The VIS also noted that the granddaughter had received counseling for several months after the incident, but eventually had stopped because she concluded that no one could help her. So, the outcome of the case came down as the jury sentenced Booth to death for the murder of Mr. Bronstein and to life imprisonment for the murder of Mrs. Bronstein. An automatic appeal, the Maryland Court of Appeals affirmed the conviction and the sentences. The court rejected Booth's claim as the VIS injected an arbitrary factor to the sentencing decision. The court noted that it had considered this argument in the Ladowski v. State, and it vacated on other grounds, and concluded that a VIS serves an important interest by informing the sentencer of the full measure of harm caused by the crime. The Court of Appeals then examined the VIS in Booth's case and concluded that it is a relatively straightforward and factual description of the effects of these murders on members of the Bronstein family. It held that the death sentence had not been imposed under the influence of passion, prejudice, or other arbitrary factors. So the question was, does the Eighth Amendment of the Constitution, which protects a defendant from cruel and unusual punishment, prohibit a jury from considering a victim impact statement during the sentencing phase of a capital murder trial? So here we have Booth. They put together and they petitioned to a higher court, so the state of Maryland. Petitioner's claim was that Maryland violated the Eighth Amendment by letting the jury hear evidence about how his crime affected the victim's family. So some information about this. In recent years, the so-called victims' rights movement has achieved considerable success in increasing the attention that the criminal justice system pays to victims of crime. Examples are as diverse as substantive reform of rape laws, enactment of rape shield laws, passage of Federal Victim and Witness Protection Act, and the success of organizations such as the National Organization for Victims Assistance and Mothers Against Drunk Driving. One consequence of the victims' rights movement is the increasing importance of victim harm and determinations of an offender's sentence. One element of this trend is the use of victim impact statements, now employed by various forms by 38 states and the federal government. A victim impact statement describes the effect of a particular crime on the victim and his family. The statement is presented to the sentencing authority, who must consider it when imposing punishment. So the petitioner again appealed to the U.S. Supreme Court after it was turned down again. So the lower court's sentencing was vacated and it remanded back for further proceedings. So, the presenting arguments before the Supreme Court, the chief attorney for the petitioner argued that when deciding about the death penalty, juries should only consider two criteria: the defendant's background and the circumstances of the crime. He pointed out that neither criterion was part of the VIS presented during the client's sentencing phase. Counsel also pointed out that typically persons who gave statements in a VIS were not witnesses to a crime, so their testimony should not be considered admissible as aggravating circumstances. Moreover, the petitioner's attorney maintained that information collected and presented in a VIS was individual and therefore not of consistent value in all cases. Each family has a different ability to show grief. Thus, the VIS presentations varied greatly. In fact, he maintained that some victims were without families, and therefore a family-less VIS would likely impact the jury's deliberations differently than a VIS containing the personal statements of a victim's family. Finally, the counsel posted that a VIS that contained emotionally charged opinions by family members would be inconsistent with reasoned decision-making required in capital cases. So upon deliberations, the Supreme Court found with a majority decision that the VIS to jury deliberations during the sentencing phase of a capital murder trial posed a risk of over-relying prejudicing a jury and thus violated the Eighth Amendment. Justice Powell, writing for the majority, observed that in a capital case, the jury sentencing task is based on consideration of a defendant as a unique individual. The focus of a VIS, however, was not on the defendant, but on the victim's character, reputation, and the effect of the crime on the victim's family. The justices agreed with Booth's attorney the potential for admission of emotionally charged opinions that might be presented in a VIS was irrelevant to sentencing deliberations because each family possesses a different ability to show grief. The individuals highlighted below actually went with the decision 5-4. So, upon conclusion, yes, the court found that the victim impact statement created a constitutionally unacceptable risk and violated the Eighth Amendment. Justice Powell argued that in a capital case, the jury's sentencing task is based on the defendant as a unique individual and not on the character or impact of the crime on the victim's family. Allowing the content of a victim impact statement to influence the jury could lead it to choose the death penalty for reasons which were irrelevant to the defendant's decision to kill, thus diverting attention from the facts of the crime. Furthermore, concluded Powell, introducing the emotionally charged opinions of family members into processes would erode the reasoned decision making, which is crucial in capital cases. And here are my references. Thank you. Have a wonderful day.